transition. We have a witness, one witness here today, Brooke Dingledine. Who's right here? Right here. You're ready. Right in the. Oh, there. Yeah.
Can't recline. Uh-oh, I didn't.
Not a
I had
common
chocolate
plus.
yesterday. Was we gonna squeeze in?
All right. Welcome.
Thank you so much.
Dingledine.
I'm a little out of breath. I was successfully avoiding a crash on the interstate on the way in between Berlin and here. So I have to tell you I am a little bit jumpy because I still have some adrenaline rushing through my body right now. So
We're glad you avoided it.
Yeah,
Hopefully others
indeed.
were not hurt.
it didn't look too bad. They just went off and didn't roll, thank goodness. But I did risk coming here today. I've been doing that commute for 25 years to my office in Barrie, and I'm old enough now to know better than to come out on a day like this. That's how important this is to me. I'm not a lobbyist. I come here representing no particular interest. The strength of my testimony and experience, and hopefully that will serve you, is that I have represented all sides, except being a prosecutor for one of the environmental entities. I have represented large developers on national quarry projects. I have represented small developers on many, many tower cases when they were in Act 250, and municipalities, individuals, folks that coalesced as a citizens group, and also individual folks. In Act 250 and before the Public Utility Commission. I've had 25 years experience in Act 250, Public Utility Commission in the last few years. I'm reminded of those Dr. Seuss quotes. I am the Lorax, I speak for the trees. I speak for the trees, for the trees have no tongues. I also speak for Vermonters, because you have had this proposal privately crafted and then presented to you as a derailing of the process that you have gone through for the past 2 years. 1 year ago, I was here testifying before the Act 250 Commission, but I think some of you were on that. And what I said to you is, there isn't a huge problem with Act 250. What there is a problem across the street at the Public Utility Commission. If you folks are truly worried about protecting the environment of the state of Vermont and making sure that Vermonters do not lose the value of their homes to solar projects, NextEra, for example, has 5 of the last 6 standard offer contracts awarded to them. The one that I'm most familiar with is being proposed 1 mile south of Vermont Technical College. It will consume 110 acres of prime ag soil land, and it will cut down enormous swaths of forest. In an area where this is at Randolph, and I live in Randolph, where there is a 5-section area where you're notified on the interstate by signs that there are moose crossings. This is a couple hundred feet from the interstate, right at 1 mile south of the exit 4 exit. The reason why I'm so concerned is that NextEra, for example, proposes 195 solar panels on 110 acres. Prime ag soils doesn't matter at the PUC because they say, well, it's not permanent. We're not destroying any soils. They'll be available in 20, 30 years, or maybe 50, 60 years, because they might exercise the automatic option to continue to have this project. You guys are fiddling and micromanaging with the system that actually is not problematic. Could it use some corrections? Absolutely. Am I concerned that sometimes district commissions decide things that maybe a legally trained environmental court judge could decide better? Probably. But where are the statistics that suggest that there's any statistical significance to the notion that there is not consistency between district commissions in Vermont? Where do the appeals go? The appeals go to the Environmental Division of the Superior Court. What kind of review is it? It's de novo. That seems to be a dirty word now here in the State House. De novo review is so important in this context because I don't know how much information you folks have been given about what it's like for a litigant to go through the Act 250 process right now. The developer goes to the district commission. They've had 2 years probably to craft this proposal, present it with all their experts lined up on aesthetics, on wetlands, on whatever those things might be. So what happens? People may find out about it, they may find out from their neighbors, gee, or there's something going on nearby, should I be involved? Gee, I'm in a butter. Or, gosh, this is not what our community wants as a town and municipality. So, what happens? Well, we want to intervene. We want to be heard on this as Vermonters, as a neighbor to this project. So, they find out about this. There's some hearing and site visit, and they have to show up, and they have to ask for intervener status. Okay, but you don't know for sure if you're going to get intervener status. So what's that person going to do? Or the municipality obviously has statutory standing, but for an intervener individual Vermonter or nearby business or what have you who wants to get involved, they are facing something that's already been developed over 2 years with every expert already, locked down. And now they have to figure out, what am I going to be granted intervention status on? And then I gotta go get an expert, or at least have to go and testify and participate. So what I normally tell a lot of folks in this instance, this is how I help Vermonters participate in that process. I say, go to the district commission. I help them somewhat, craft what they're going to say. I explain to them how they need to establish a particularized interest that is not otherwise adequately represented. That is the legal standard for allowing them in the door. So they go through that process, they ask questions, they are able then to establish the standing to be able to appeal to the environmental court if things don't go their way. But at the district commission, there is a process, there are staff members, there are coordinators and other folks at these offices who help not only pro se's who want to know about so-and-so's development, big or small, but they also help particularly the small developers, the small mom and pops operations that need now to do an Act 250 permit because they want to make a change in their business property, and all of a sudden they're thrown into this arena. So I say to them, prepare your project and go to the district commission. Have them help you they help make sure the applications are complete. There is a lot of boots on the ground, whatever it's called, effort from those wonderful folks at those district commission staffers that help these folks do this. Now I know you're talking about, okay, I guess the little ones will still go through that process or something. But it's the appeal. Where is this now going? If I get a decision I don't like, either as an opposer or as a project proponent, I get to go now to the environmental court, and that's the real show. That's a de novo hearing. But I want you not to be frightened of that. That is an incredibly important process, and I have heard that there have been scare tactics saying, well, this is a second bite at the apple. If the opponents can't stop it on the first try, they get another try. They don't even have a first try at it, honestly. And it's not like the entire project gets appealed for a de novo hearing. They don't have to come in and do their dog and pony show with every one of their experts to parade through all of the 10, however many there really are, criteria. If it's aesthetics, that goes up on appeal. It goes to the environmental court. What happens there? If people want discovery, they have to ask for it. Environmental court has complete control over discovery, and they decide, does this case warrant allowing any kind of process, either interrogatories or depositions or anything, or are we just going to make sure everybody has the materials of all the pre-filed testimony of all these experts, and they have a hearing? Now, often you don't even need a hearing at the environmental court. They file a summary judgment motion and says, here's their evidence, here's our evidence. Make a decision. Now, if they have no disputed facts, it can be disposed on summary judgment. If they have a dispute of fact, then they have a hearing, and the environmental judge, who's law trained, understands the big book of precedent from the environmental board, which has equal stature to court precedent, but they have also developed the precedent for 17 years, I don't know how many years, 15 years, whatever it's been. Now, I practiced for 10, 11 years in front of the environmental board, which I find the court much more consistent, reliable, has a better, optic, because, trying to figure out the easiest way to try to explain this. To have a de novo review allows new evidence. That's the only important thing about de novo versus on the record in terms of what is looked at by the court. So, whether it's the court or some other board that is being proposed, you're comparing two things. One is we presented our application and maybe there may be a couple criteria that then are reviewed. And guess what? When they're reviewed, the court gets to look at the evidence and make a decision. If you do an on-the-record review, depending on what standard of review that you impose, which I have not heard, but my assumption is that it's on the record, because I'm understanding that right now the proposal is the big projects go to the NRB or some panel that they're creating, and it's a one-shot deal. And the only appeal from that is to go to the Supreme Court. Well, the Supreme Court is an on-the-record court. They don't take evidence. They don't have hearings. And the only decision that the Supreme Court makes is, did they abuse their discretion? That is a hugely difficult standard. You have to prove that they made such a big mistake that it wasn't supported by even a scintilla of evidence. No rational person could have decided, what they actually decided. That's how big a mistake that you have to prove. Well, it's a fait accompli.
Say that one more time. The Supreme Court, they only consider
Abusive discretion was the mistake by, for example, the Public Utility Commission, because this is the very model that you are patterning this after, maybe unbeknownst to you folks. But at the Public Utility Commission, I have gotten involved there because the town of Bennington spent $200,000 trying to fight 2 solar arrays by out-of-state developers. That's the bigger threat. These folks, Alco, Renewable Energy, the Malones, they have so much litigation going on. They are suing the people who were left standing. The neighbors to the 2 solar array projects are the only ones left standing, because after Bennington tried to intervene and have their say about, gee, this is what our town plan says and this is our interpretation of it, they ended up getting sued in several different forums by the developers. And after hemorrhaging $200,000 in attorney's fees and staff time, they finally said uncle, and they cut a deal where they said, okay, we will not oppose any solar project they had 4 in the pipeline. So they had to compromise and say, we're just absent, we're not going to do anything because we can't afford getting sued in yet another place. And so to stop the hemorrhage, they withdrew. The only people that were left standing was a homeowners association that was abutting the project, and one elderly lady who has fought this since 2013 on her own. So the process is you have to have a lawyer, and these people have done an incredible job with the guidance of Vermonters for a Clean Environment. They came to me when they had their technical hearing on the first array. I went and I cross-examined witnesses. I was told when I made evidentiary objections, too bad, your pro se client should have done that 2 weeks ago, and because they didn't do it, our rules say in some memo somewhere, not even in our real rules, they blew it. They didn't know how to participate. Too bad the burden was on them to try to figure it out. So I'm sitting there as a lawyer going, but you're accepting evidence that doesn't even pass the straight face test. For example, one of the arguments was, well, the town of Bennington supports this because they withdrew their opposition. That was absurd. We had to go all the way to the Supreme Court. We've gotten a reversal. This is only the third time that a CPG has either at the PUC or at the Supreme Court been denied. Thousands of of CPGs have been issued, and nobody is able to get in there and to put the developer's feet to the fire and say, is this really going to cause environmental damage or destroy the aesthetics and therefore the grand list of the municipality that is here at issue, because now they have to reduce all of the valuations of the abutting landowner's property. So I've heard some discussion about, well, we'll do like a Department of Public Service kind of public advocate. That's what we need. Well, I am here to tell you that the Public Service Department model in terms of being in these proposed projects is abysmal. They are not helping the people who are abutting here. Let me back up for a minute. Public Service Department's job used to be with utility rate setting. They were the public advocate that went in there. They knew what they were supposed to be arguing. They knew what delivering, what representing the position and the best interests of Vermonters were by going in there and saying, sorry, I lost my train of thought. Public Utility Commission. So in rate setting cases, they end up arguing for the lowest rates. Prove to us why you need to raise rates. And they know what their role is. Well, unfortunately, in these private entities coming into Vermont now and being able to do these solar projects or wind projects, what happens is that the Public Service Department, they get to be judge, jury, and executioner. Do we like this project? Yeah, let's support, and by and large, most of the time, they support the applicant. And you folks, the legislature has given them funds to be able to hire experts so that they can actually litigate and theoretically advance the public interest and say, no, developer, you have to prove that you're not going to destroy our ridge lines or that you're compliant with the town plan or whatever the criteria might be. Now, unfortunately, what has happened to our hard-earned tax dollars is that the Public Service Department has used those funds to hire an expert and then bring them to trial, do the pre-filed testimony, the paper goes back and forth between the lawyers. I mean, you're lucky if you even get to cross-examine any of the witnesses at the technical hearing anyway. And the problem with this is the Public Service Department hires the expert to say, yep, we are thumbs up. There is no undue adverse impact on aesthetics or whatever the criteria might be. And so we are then spending our money hiring an expert to say the same thing that the applicant's expert is saying. Why are we wasting our money like that? Now, I'm sorry I've gotten so far into the weeds about the Public Utility Commission, but the important point of it is that you have a 3-member board there. They go through the judicial nominating process. One of them is a lawyer, maybe 2 of them, I'm not sure. And yet, it's a bureaucracy. This is not about any kind of local control or people in a region of Vermont having that unique and special information and knowledge of not only the topography and the towns and what they believe in for their goals and their town plan. You don't have that local control or local influence that is critically important. I can't tell you how many times I've called a district coordinator. Ed Stanek, for 20 years I talked with him. Julia Schmidt down in District 3. Bill Burke over in Rutland. These folks are critical to this process, and now you're creating this 3-member board. What are you going to do? Create like an entire massive district commission kind of staff to be able to, help interveners get through this process at that level? If you had that initial whatever it is with whatever it is, district commission or this panel or whatever, and then there is an opportunity for an appeal to the environmental division to be able to review this de novo. And it will only be, 1, 2, 3. It's not the whole project. That is essential to due process, to allowing equity and folks who don't have bankrolls like big developers to come in and to still participate in the process. You are shutting out Vermonters, you are shutting out municipalities. And I'm not talking about itty bitty little towns. I've represented them too. And, you know, done magic with $2,500, $5,000, because that's all the town can afford. I do a lot of pro bono work, because somebody needs to do this. It is not being protected by the process at the PUC. That's why I said you are fiddling while Rome is burning. If the NRB wants more power, jurisdiction, and control over the environment of Vermont, then stop this process. You want forest fragmentation protected? It's like a drop in the bucket compared with the amount of acreage of the state of Vermont that is now being raped by out-of-state developers and are getting rubber stamped. Now, I will say that this new composition of the Public Utility Commission has done better. They seem to be listening to some of these issues, but it is still an arduous and such an expensive process that it is impossible for anyone to have any kind of say there unless they have an attorney. So, where are you on the Act 250? Let me just make sure I get everything. So let me just say one other thing about 2 bites of the apple. Yeah, you can look at it like that, sure. I don't think that the public, the the municipalities, or the individual Vermonters, I don't think they ever get their first bite of the apple. I think it's like bobbing for apples. They keep trying to grab but it's floating around and they can't be heard. Now, but one of the things that you need to think about is, what about the second bite at the apple for the developer? Carl Rinker, Rinker's Communications, was my client for over 20 years. He used to go as a fairly small developer, and he would go through the district commission process by himself. If it got appealed, if there were issues of concern, he'd bring me in to help mediate, work with people. That's what happens at the district commission. That's where the individual Vermonter can be heard, can say to the coordinator, I'm concerned about this. They can set up a mediation. I have volunteered my time as a mediator in Act 250 cases to try to, as a lawyer who's not representing either side, try to bring together as a mediator what these concerns are. And so through that process, if they get the agreement to the buffer that they want, and they're going to plant the trees so that they're not going to see what is being built, that all works out at that level. Now, what happens if the developer, they get denied on stuff? Well, then they can go and they can have their second bite at the apple on those few things that they might have been denied on. I have never seen an application that's ever been denied on every single criteria. It just doesn't happen. And so I think that you have been given a misperception of how this whole thing works. And I honestly haven't a clue how many people you are going to have to hire and what kind of structures you are now in offices and staff that you are going to have to create. Because I'm sorry, Evan Meenan is a wonderful person. He can get through massive amounts of work. He is one of the hardest working people I've ever met in state government. But guess what? He's not going to be able to do this. You're going to have staff people all over the place, replacing the people you already have. So now if we throw a bone, we want it to optically look good because we're going to keep district commissions. There's no job for them according to what has been explained to me. First you wanted JOs to be done. Why? The district coordinator is going to write it anyway for them. That's what happens now. So one other thing that I wanted to bring to your attention, and that is, I do want to remind you, there's no data or statistics that have been presented to you that suggest in any way that the environmental division, that there's evidence from reversal rates, that there's any inconsistency right now as per different origins with regard to the district commission decisions. I would be shocked if that were the case, because what you need to understand also is that over the 25 years I have observed Act 250, The NRB now has taken a much more active role in what happens at the district commission levels. I think you've heard from Bill Burke last year about being sort of given marching orders about, the chair wants you to do X, Y, or Z. Improperly reaching past the jurisdiction of the chair and compromising the district commissioner, district coordinator job, jurisdiction, and authority. It's not the chair of the NRB's job to tell the district coordinators or commissions what to decide. For JOs, they are the appellate body. They're not supposed to be writing the original decision that then they're going to say, yep, thumbs up to, we agree with that. They're supposed to be in a position to actually review what has been decided and correct it if it's wrong. So that's troubling, but that has been an evolution of what control and power that they have had. Because the other thing that's happened is with the centralization of like the Word documents of the district commissions, apparently the NRB lawyers can get in there. They micromanage those decisions, they rewrite them. They're in on the network or whatever drive this is that they're looking at the decisions. So they're helping to write the decisions. So if there isn't consistency, I don't understand why there wouldn't be, because the NRB is pretty much in control of this, and this has happened. And so I have to kind of chuckle to myself, because in certain respects, putting the NRB explicitly in control is more transparency in terms of what the actual operation and way in which this is being exercised is happening. So what happens with a permitting decision? Well, they apparently have input into the decision. I was at an Act 250 hearing before a district commission not long ago, and the NRB general counsel was there. And when a question came up for the district commission, they're like, we need to go talk with our attorney. And I'm like, who's your attorney? And they went out in the hall with the general counsel for NRB to get legal advice. I'm like, what? What's going on here? So I think there's been a role confusion. Now, when the appeal from district commission decisions on permitting goes up to the environmental division, NRB comes in as a party to that. They actually litigate like as if they now have some standing, and they have some standing to then be involved in that process. They shouldn't be involved in that process. Again, they should not be involved in what the district commission is deciding. So there have been these blurring of lines of authority. And now this seems to be some kind of continuing evolution. Now we want complete control. We want it centralized in Montpelier. I think that this is the very antithesis of what Act 250 is about. It was designed to protect our environment and to make sure that Vermonters had a say, and there was a good balance of economic issues as well as protection of the environment. If you don't have somebody sitting at the table and you vote for this derailing private agreement where arms were twisted and everybody got their bone thrown to them and then they compromised on the rest, that process didn't involve attorneys who do what I do. It didn't involve Vermonters who have been through this process. I think Laura Block, one of my clients in Bennington, she was one of the people that has stood firm after Bennington had to fold their cards and leave the game. She has described to you what the Public Utility Commission process is all about. And that is what I fear. You have a bunch of bureaucrats in Montpelier. Okay, what are you going to do? Borrow somebody from the region? Those people get paid, what, $50 per diem? And somehow, I don't know whether they have voting rights or not now, but why are we centralizing all of this? We have centralization of it. We don't need to train people now and put them through the judicial nominating process to figure out whether, and vet them to figure out whether they could be akin to an environmental law judge, which we already have two of them who do an excellent job. I think that Brian Grierson has testified with regard, he's our chief administrative law judge of the trial court system. I think that he has explained to you that 80% of appeals get disposed of at the environmental court in less than 1 year. That is astonishingly fast. Of the remainder, have you been provided any information or data that shows that there's a problem. I'm sorry, you're trying to fix something that is not broken. Yes, there are improvements, and maybe NRB has a bigger role. But for God's sake, what you should be doing is throwing this out the window and sitting down and saying, how can we control the environment of Vermont? What I propose that you do, I don't know what you know about the PUC Section 248 process, but I believe it was Michael Marks, an attorney with Marks and Gillis long ago. Now they have a different name, but you know Jerry Tarrant. And Michael used to work for the Public Service Department many, many, many years ago, way before my time. And what he did at that time was he proposed and got enacted by the legislature the importation of the Act 250 criteria into the Public Utility Commission process. So that's why they're supposed to go through all of those things. Well, unfortunately, and I alluded to this earlier, those reviews are sorely inadequate. Act 250 does a wonderful job at that. Have I run into frustrating cases that took too much, or I felt that there were litigation tactics, or that maybe the district commission was not as schooled as they might have been? Yeah, but my overwhelming experience has been excellent decisions from district commissions, even if I appealed them. But then you get an opportunity to be heard. It is the process that you need to provide to people. This is about their land. There is nothing more essential in terms of property interests that are constitutionally protected that you need to give due process to this. And due process requires seeing what evidence it is that you're making your decisions on to change and alter people, that serious consequences on their value of their property, that they have relied on certain kinds of planning documents. For example, I was told recently, in Randolph, I've been fighting down there because Braintree next door to us, through the town planning process, decided they were going to make solar resource map, which is just a map that shows where the sun shines. That's going to be their preferred sites map. Anywhere in the town where the sun shines, you can put a preferred site, meaning you basically get fast track to a permit.
I gotta interrupt you because you've been going for half an hour and we have other things to do. And I want to give committee members a chance to ask you questions
Sure,
about
sure.
Act 250 stuff.
Yep, I will.
Which is why we're here. We're here
Yep.
for Act 250.
Well, I understand that, but what I'm trying to demonstrate is that the process that you're going to has already been tried and it is failing miserably. And so I'm trying to jump in front of the freight train that has already left the station. I know it's probably a useless exercise, but I have to implore you, this is going to have serious negative ramifications on people's ability to protect their homes, their property, to have a say, and for you to create a system that serves Vermonters. I'll take whatever questions that you like.
Questions, committee? Jim?
Rather than ask what similarities between the PUC process and the new enhanced natural resources board is, I would ask, what are the differences?
I don't know, because I don't know all of the details. I mean, that's part of the problem. Obviously, this is this changing thing. 1 minute it's one thing, the next minute it's another. Well, I guess I'll ask you some questions. So, in the first instance, the large projects get sent to the whatever this board is that you're creating.
The board.
The board, okay. Now, what happens there? Are there staff people to help interveners come in and say, for example, here are the forms that the environmental court has, filled these out.
Just to let you know, the current model, and that's how the legislature works. We work through and we have a process and it's very deliberative and it changes all the time what's in a draft bill. That's just what happens here. And that's happening now in this bill. And so the proposal on the table is we keep the district commissions and district coordinators are in place, and that pre-application process is what you're talking about is there. There's a pre-hearing meeting, we're calling a meeting, that we've heard a lot of great testimony and support for on both sides. So we think that there's actually ways that we can strengthen the public's ability to have their first bite at the apple. I mean,
And are you providing any funding for either lawyers or for expert witnesses for these folks within the process? I know that has been requested by some folks.
It's been requested. Currently, I would say no, but we're in that we're going through our draft bill today, trying to get through it and having those conversations.
So my concern is this: I'm not going to be able to be here for the next 3 days while you micromanage all of these things, and nobody is here at the table, which is why I can't understand why the whole study committee and commission process all of a sudden gets derailed because some people make this backdoor deal and then put it in front of you and say, do this instead. Now, I don't, okay, so, but it's all of the devil in the details. How much staff and money are you creating to be able to have something similar to the same support? Environmental court, for example, has many, many forms. Okay, here, fill this out, this gets you in, this right, fill in the blanks,
I think Jim had
that sort of thing.
Yes, I do very much appreciate your coming here with this message. I want to, with my question, which I didn't really get an answer to, I want you to put a fine point on the concern that has been voiced many times in this committee, that the new enhanced board, whatever fine details get done with it, is the PUC process remade, and would result in result in the everything you've said about your difficulties and expenses in front of the PUC. Do you see that? That's why I asked for the differences instead of the similarities. Do you see that as your major thesis here?
Because I don't exactly know the details, and I'm not sure you folks do. It's very hard to compare. What I can tell you is that the Public Utility Commission, it's just lawyers writing pieces of paper back and forth.
Yeah, thank you very much. Yeah.
Including just discovery questions. The next week you have to answer them, then you have to send back and forth and back and forth. Pre-filed testimony, rebuttal, rebuttal, back and forth. That's all that ever happens there. And then you have this pretend hearing that really, you're told you can't object to anything. So if you're going to do it this way, and you are going to stick with this, then it's on the record, appeal only to the Supreme Court. That is the madness. You must give a de novo review, because I do not believe, unless you're going to stage this, number one decision you gotta make, are you gonna give somebody intervention status? Then you're gonna have to give them time to, once you say yes, okay, now I can go get an expert. Otherwise, they're left in this conundrum, do I spend the money? I don't even know if I get in the door. And you have to, and it's unfair. The developer has done this for 2-3 years even. And all of a sudden you have 30, 60, 90 days to get up to speed. To even find somebody is a real challenge, because nobody even wants to work for anybody but the developers. They all want to be hired continuously to do these projects for people who have money.
Thank you so much for coming in on a very snowy day.
And I understand that the train has left the station. Let me just close by saying one thing. My son was a legislative page here 8 years, in 8th grade 4 years ago. He's a senior now. And when I thought he might be off from, he goes to VAST at DTC for his senior year. And I thought they might cancel school. And I said, you want to come up and listen to some testimony? Kind of revisit your stomping ground. And I told him what it was about. And he turned to me and he said, so what's going on here? This is a political thing, and people are being arm twisted into doing something instead of stepping back and saying, no, this isn't right for Vermonters. He said, you know what this reminds me of, Mom? When I went to the Kennedy School of the Senate last year, and I was given an identification of, I had to be a Republican senator from Alabama, and I was given 2 charges. One was, your party says I have to do this, and your constituents' best interest is that. And then we went through the process of being arm twisted into making a decision that was not right for our constituents, but that followed the party line. And he said, this sounds like they're doing exactly what just happened in the impeachment trial, what the Republicans did. And I said, well, Joseph, that's certainly one way to look at it. I'm going to go talk with these folks and beg them not to cave to this political arm twisting. Do what's right for Vermonters. Please, this is a disaster waiting to happen. I implore you, please think about the Vermonters who are going to be harmed, lose the value of their property, and have no review process where their concerns, their voices are actually heard. That's what Act 250 is about. It's about to protect Vermonters and our environment while making sure that all the best interests of our economy are served as well. Thank you very much for your time.
Thank you. Okay, yeah, one question.
I appreciate you covered a wide range of topics relating to Act 250 in a short period, relatively short period of time, so I appreciate that. You also mentioned, and you brought in the 248 process, and as you know, they use the same criteria, Act 250 criteria. And I'm just solely focusing on narrowly about that, sharpening that pencil to try to articulate the value and the importance of the criteria provide. And they are somewhat differential from each other. They're unique to address a unique quality or landscape feature that we all hold dear. In your opinion, would it be helpful to have some purpose statement up front in the statute when we talk about the Act 250 criteria to reflect that it is in fact the intent of these criteria is about ensuring that projects that move forward are considered what's in the best interest in our for the people of Vermont. That meeting these criteria are to achieve is in fact in the public interest.
You mean in a way to try to guide the Public Utility Commission?
Well, and that way it would run with the criteria, but it helps to reflect that the set of criteria, the reason behind it, the policy, the intent, the value is in fact in the public interest.
Oh, absolutely. But then the nuts and the bolts of it have to be in the public interest. I mean, policy statements are great and what's the intent and everything, but you're never going to get there because the plain language of the statute's going to rule. And now, let me just say about the Public Utility Commission and why I think it's super important that you really step back and say, maybe we should be doing that. The Act 250 portion, the land use portion of what's going on over there is the piece that you folks need to grab. That needs to be done at Act 250. And leave all the technical stuff over there with the Public Utility Commission. They do all these feasibility studies and the grid and all these other things. Leave that over there. But you guys take back over those Act 250 criteria because they don't interpret them in the same way Act 250 does. There's a modified Queechy test that basically says, well, if you fail on, Queechy is 3 standards. Clear written community standard, shocking and offensive to the reasonable person, and then whether there's reasonable mitigation imposed. And so you have to pass all 3 independently in Act 250. What do they do over there? Well, if it's shocking and offensive, we get to double count sort of the mitigation and say, but the mitigation makes it so it's not shocking and offensive anymore. So they kind of double count that, and it pollutes the way in which that the evolution of that law and the interpretation of it has happened. It needs to come back here. Forget about all this what's going on. It's okay. You can do some fixes.
Mr. Vice Chair,
Yes.
I for one am very sympathetic to the testimony, but I'm going to ask that we're doing the Act 250 now, and we've heard adequate time on the PUC, and suggest that we move on with our council.
I have one question before you leave.
Yes, sir.
One of the criticisms we've heard is the way the present system operates now, there's a lack of consistency. And I'm wondering, as a lawyer, and coming in front of 250, if you find yourself kind of befuddled because the decisions are not consistent and you're kind of left wondering what should be emphasized or not.
I don't find, I have had a couple cases where I've been frustrated and I haven't liked the decisions, and those have been appealed. But in terms of any kind of systemic inconsistency, absolutely not. I have not experienced that. And what I say to my clients is, don't worry about it. We get to go to the environmental court and they will save us. Whatever that is, they will apply the law consistently no matter what. So I think that the chair asked for statistics when this argument about consistency was being raised, and nobody has presented anything. Before I came up here today, I ran into Brian Grusin and I asked him that very question, and he told me, absolutely not. I have no data that in any way suggests that. And then he told me about 80% are dealt with. Look, it's only a small percentage of them anyway that are appealed. The ones that are disposed of in less than a year. That is like light speed, warp speed, whatever you want. That's incredible. Quick. And we have a body of law. That's a whole other thing. Let me just say one other thing, please. And that is, in the Public Utility Commission, it's this little board making all these decisions. I can't find the decisions on Westlaw. I can't, unless you're there every day and people are like, oh yeah, there was that Plum Creek, whatever the name of the case was. Here we have an environmental court that has a body of law that will continue. We don't want to make it impossible for people like me to figure out, well, I don't know what they said on the last case because I have no way of searching it. Are you going to buy them a whole computer system and upload all the decisions and make it a searchable database and all those other things? I don't know the answer to that. But there's so many practical obstacles here. I implore you not to do this. Step back, figure out the broader picture, and then you can monkey around with it. Please don't do an on the record, please. Thank you.
Thanks so much for coming in.
Thank you.
We changed rooms so that we would have more room, and actually we do.
Thank you.
Thank you very much.
Thank you.
I really appreciate it. I just want, Mr. Grimes was very helpful, and I didn't want to suggest that I was shooting the messenger. I appreciate him helping to get some time. Thank you.
Thanks for coming in.
Thank you.
All right. Thank you for your statements. We are, what's the committee's pleasure right now?
My pleasure is a short bio break,
Yeah.
but get back in the traces.
Okay, good. Let's
Yeah.
do that. 4 minutes.